Minister Edwin Tong.
Thank you, sir. So I thank the members for the support of this bill, and I'll jump straight into answering the various queries that have been posed. Mr. Murali Pillai, Ms. Sylvia Lim, and Mr. Louis Ng, Mr. Zulkarnain, and Mr. Vikram, I believe, asked how we can ensure accessibility to PTIBs. Sir, there are sufficient insolvency practitioners in Singapore to take on new cases. I think Ms. Lim herself from her research found 187 licensed insolvency practitioners. Of this, the vast majority, 183 of them, are eligible to take up bankruptcy administration at present, but only a third of them, about 56, currently do so. So in other words, 150 of the 187, 183 of them are qualified to take on this role as PTIB, but only about a third of them are currently taking it up. Obviously, under the older regime where only ICs appoint PTIBs. So in other words, there's a sufficient headroom for this to grow into that space. And should there be a need to review these numbers, we will do so. Ms. Lim also asked about whether information about the PTIBs could be made accessible and how would someone who wants to file a bankruptcy claim access that. We'll put a list of the PTIBs on the Insolvency Officer's website, and debtors and creditors will be able to use the information that is on the list to discuss with PTIBs about the appropriateness of taking up the cases and which PTIB they might want to go to for the appropriate administration. Some questions were also raised on the PTIB's fees. Their fees are based on work done in a particular case and determined in line with market forces. The fees which are paid out from the bankrupt's estate are ultimately approved by the creditors committee or by the court if there's no such prior approval by creditors. These mechanisms collectively, they work in tandem to introduce checks on PTIB's fees to ensure that they are in line with market and that they are reasonable. Mr. Murali observed that debtors may face problems applying for bankruptcy, I presume, after these amendments. But I want to assure Mr. Murali that the threshold for the filing fee, the bankruptcy fee, $1,850, hasn't changed with these amendments being introduced. The PTIB's fees, additionally, may also be recovered from the bankrupt's contributions during the lifespan and the whole duration of the bankruptcy. In other words, you don't need to have had sufficient assets at the outset to meet the fees before the administration can start. Along the way, there might be realizable assets that are called in, and this includes property acquired after a bankruptcy order as well. So all that collectively comes out of the bankrupt estate, and they go towards the PTIB's fees. Mr. Zulkarnain asked whether the PTIB's work might overlap with the work done by debt recovery firms, credit counseling firms. The answer is no. These firms take on the work pre-bankruptcy, so they might go and recover debts, they might go and issue demands and so on. But once the bankruptcy takes place, that's when the PTIB steps in. And it is only on the making of the bankruptcy order by the court that the PTIBs are appointed and their jurisdiction then begins. There were various questions on the official assignee's role. Mr. Murali, Mr. Zulkarnain in particular sought clarifications on the circumstances on which the OA is expected to administer the estate of the bankrupt. So the bill gives the OA the discretion, as I mentioned at the outset, to give consent to take on the administration in a particular case. But let me just remind members that this framework is designed to mandate the appointment of PTIBs. In other words, the whole raison d'etre behind this is to ensure that cases are administered by the PTIBs. So when you ask about what happens when there's no such PTIB, or what happens when in what cases can the OA step in, I would say as a starting point that it's got to be very narrow. That will be in line with the philosophy of this bill, to keep it narrow so that parties go to the PTIBs. And it is only in the appropriate cases like what I mentioned at the outset, for example, public interest examples I cited earlier, or perhaps given that the powers of investigation and prosecution don't devolve to the PTIB, they remain with the OA. Perhaps in a case where you know from the outset very clearly that heavy investigation will be needed, or that there are likely to be prosecutions. In that case, perhaps it might be appropriate for an OA to take on that role from the start. But really, those are examples, and I mentioned that they are non-exhaustive earlier because you've got to look at the entire factual matrix, the particular circumstances of each case to decide whether or not the OA should grant consent or should take on the role itself. In addition, as provided by statute, the OA will step in to administer the bankruptcy estate in the interim. And I think Mr. Murali raised this point. So in cases where an earlier appointment of a PTIB fails to take effect or the office becomes vacant after it had taken effect, then in such scenarios, the OA will step in. It will step in, and this question of consent or otherwise becomes irrelevant because the statute mandates that the OA steps in so that there is no disruption to the administration. Mr. Luizeng and Mrs. Zulkarnain asked how the ministry will ensure effective oversight and quality of the PTIBs. So the OA has been regulating PTIBs since 2016, when it was made mandatory for ICs bringing bankruptcy applications to appoint PTIBs. The ministry already has in place a robust regulatory framework to ensure that the PTIBs perform their duties faithfully and observe all statutory requirements relating to the performance of their duties. So, for example, the law confers powers of oversight over PTIBs on the OA, to whom creditors and bankrupts can also provide feedback on the conduct of the PTIBs. In particular, members would also be aware that under IRDA, there are obligations to notify, obligations to submit a copy of the Statement of Affairs, to submit a report 30 days after the relevant anniversary of the administration date of the bankruptcy, and so on. So this gives the OA the ability to look into the particular administration and for the PTIB to provide information to the OA. PTIBs are also required to put up security, which the OA can forfeit if the PTIB does not fulfill duties and responsibilities in accordance with statutory requirements. And indeed, if there's dissatisfaction with the PTIB's administration of the estate, the OA, as well as creditors or debtors, may apply to court for various orders, including orders to modify the PTIB's acts or decisions, or indeed, in the extreme cases, to also remove the PTIB. In this regard, it is important to emphasize that PTIBs have incentives themselves to uphold. They are held to their own high professional standards. PTIBs must either be accountants or lawyers and must comply with the professional standards of their respective professional bodies. Besides this, they must also pass various checks, including showing that they are fit, they remain fit, and proper persons to obtain their insolvency practitioners' licenses. And without these licenses, as members know, they cannot carry out bankruptcy administration, and doing so without a license is an offense. In terms of ensuring that PTIBs are kept updated on applicable law and practice, the OA conducts regular dialogue sessions with PTIBs and will continue to do so after this expansion to share best practices and developments in case law and practices. In addition, MinLaw collaborates with Temasek Polytechnic on a biannual customized training program on individual insolvency for PTIBs. Ms. Lim asked whether there have been better experiences for creditors and debtors since the last bankruptcy amendment in 2016. So over the last decade, the ministry has steadily reduced the stock of active bankruptcy cases through the earlier mechanisms, in particular the differentiated discharge framework. From 2011 to 2022, the total number of undischarged bankrupt cases decreased by 63%, from 25,028 cases in 2011 to 9,254 cases in 2022. The bankruptcy experience, sir, is generally an adversarial one, in the sense that the bankrupt would be looking to ensure that there is less or minimal monthly or annual payouts. The creditor wants to enforce, wants more share of the pie, and so on. So there's that natural adversarial process, with creditors wanting to maximize recovery, debtors wanting to pay as little as possible. In addition, undischarged bankrupts are also subject to various disabilities and restrictions. So the role of the PTIB, as with the OA before, in administering these cases, is to strike an appropriate balance in the interests of both the bankrupt and the creditor to ensure a fair and judicious outcome for both parties in the administration. It's not so much about whether it's a better experience or not, but whether it's a fairer one, whether we can strike that balance, and the appropriate outcome for the creditors in all these cases. Mr. Zulkarnain and Ms. Lim also asked if there have been complaints against the PTIB's management of the bankruptcies. As I mentioned earlier, it's an adversarial process, so there are bound to be cases where interests differ or they compete, and it is inevitable that there will be conflicts. There have been complaints raised to the OA on PTIB's management of bankruptcy cases since 2016. Many of you might well have received complaints in the course of your regular Meet the People sessions where it is perhaps said that, why is the OA asking for so much to be paid every month because I only have a job that pays me this much and I have various dependents and so on. I'm sure many of us have come across those cases. So we receive complaints like that the OA or the PTIB is too tough and asking for too much and so on. But we've looked into all of them and none of them are misconduct cases. We've not found any of these complaints to be valid from a misconduct perspective. Of course, to the extent that there are differing views as to what is the appropriate contributions, there might well be conflicts. But ultimately, as I said at the outset, I wish to assure members that ultimately the court, which appoints all trustees in bankruptcy, has the power to make orders in relation to the acts of the PTIBs, to address genuine grievances, and to seek, when the parties seek redress in the administration of bankruptcy estates. Mr. Murali raised concerns over how we can ensure that PTIBs have reasonably discharged duties that involve investigations into the conduct and affairs of the bankrupt to check if offences have been committed. I mentioned earlier that these powers of investigation and indeed of prosecution are not devolved to the PTIBs, and so that remains within the province of the OA. So in the context of a PTIB-administered bankruptcy, if there are instances where such offences might arise or where investigations are needed, then there is no change to the current position where the powers continue to vest with the OA, who will carry out such investigations into the offences and make the appropriate prosecutions, if any. This is what happens today, by the way, current position. On PTIB remuneration, Mr. Zulkarnain asked in relation to the additional means of determining the PTIB's remuneration, what safeguards to ensure that notices are appropriately given. Notices are sent to the creditor's last known address, which is also used for other communication between PTIB and creditors during the bankruptcy administration. So typically, by the time it comes to remuneration, you would have gone some way down the administration, and that would have been the address or the correspondence by which notices were given. So it's unlikely that if you have been taking part in the previous administration, receiving part of the proceeds and so on, that it would not be also the appropriate address for remuneration notices. Mr. Murali and Ms. Lim asked how the PTIB's fees can be kept reasonable. I had explained that earlier. I would supplement what I said earlier by saying this, that the OA does not regulate the fees per se of each particular administration. It's left to the market forces in the manner I mentioned earlier. And there are also parts of the legislation which ensures safeguards. PTIB's fees also have to be approved by the creditors and the court, and naturally creditors have a strong interest to ensure that fees are reasonable because ultimately they come out of the same estate. The recovery and the fees come out of the same estate. But I thank Mr. Murali and Mr. Zulkarnain for their suggestions on various things such as prescribing their notices or remuneration might be sent by emails. We'll study them when we prescribe the mechanisms. Next, on measures to protect individuals dealing with bankrupts. Mr. Zulkarnain asked about the threshold. You might recall that I said 10,000 per transaction. That would be considered an offence if the bankrupt dealing with a person in a commercial transaction does not disclose that he or she is a bankrupt in taking that deposit. This is an amount that will reasonably exclude most of the petty lower value transactions, which itself carry a lower risk signature. So we determine a threshold. If you did something too low, it'll be too disruptive. And each time you take on a small amount, you'll have to make a disclosure. And if you don't, then there'll be an offense and there'll be too prohibitive. So whilst an offense under the proposed Section 412, subsection 1D, will not be committed so long as each individual deposit collected does not exceed 10,000. But I think Mr. Zulkarnain also knows that if you are a bankrupt and you keep collecting as a habitual pattern amounts, smaller amounts under 10,000, and there's a pattern of doing so, not disclosing your bankruptcy status, which is not an offense, but then you disguise that fact and you use the deposit for some other purposes. And because you're a bankrupt, causes a loss to the person who has paid the deposit. Then I'm sure Mr. Zulkarnain knows that the OA will then have the ability to look into that conduct, and there'll be other offences collected. So this enhancement is designed only to deal with notification when you collect the deposit, and we set the threshold at 10,000. But that does not mean that should you collect other deposits and indeed enter into other transactions of a lower value, if you behave inappropriately, there could be sanctions by the OA. Mr. Zulkarnain also asked about information on employment history and status, and I thank him for those suggestions for a searchable bankruptcy database. In accordance with our requirements, the OA allows, upon the payment of a fee, inspection of this database for information on undischarged bankrupts, including PTIB details. With the amendments, we'll include employment information in this service as well. The OA is not statutorily empowered to retain or provide information on persons who have not been made bankrupts, but who are only facing bankruptcy applications. And I think Mr. Zulkarnain understands why, because it might not come to fruition that you be made a bankrupt simply because you're facing an application. And in these cases, for the OA to have to compile and maintain records of all individuals who are subject of bankruptcy applications, so much more resources would have to be used. It's not cost efficient for us to do that. I think Mr. Zul also asked about whether information collected by the trustee would be privileged. Mr. Zul would know that when a party is bankrupt, the trustee who looks after the estate owes a duty to all the creditors. In other words, the bankrupt estate is owned by the creditors in those cases. And in that situation, information about the estate should be made available to the creditors so that they can then decide whether the distribution is sufficient, whether any claims, additional claims ought to be made, and so on. But save for this, the trustees in bankruptcy generally, and we will reiterate this message, keep the information quite discreet and is limited to this pool of people who need to know and who have an interest in the bankrupt estate. Finally, Mr. Louis Ng asked how the ministry ensures that our insolvency ecosystem is equipped to deal with the latest trends in the economy. Well, we regularly update the latest economic trends, engage our international counterparts, look at the lie of the land, and get plugged into developments in this field to ensure that our framework is kept relevant. And indeed, that's why every once so often we come to this chamber to amend, to update IRDA and other related legislation to ensure that we keep up to date. In some cases, having done some market survey, market and industry feedback has led to some of these proposals as well. So I believe I've addressed members' queries, or at least the thrust of members' queries. We will take on board the suggestions that various members have raised, which we can consider as we implement the bill. I'd like to thank the members for the support of the bill, which will ensure better utilization of public resources in bankruptcy administration. It will also support the PTIB industry and also help the MSCs in the context of the SIP and enhance the protection of persons dealing with bankrupts in commercial transactions. So with that, I beg to move.
Mr. Murali-Pillai.
Mr. Speaker, sir, I seek a clarification from the Honourable Minister in his response to a point I made in my speech. This concerns basically the role of the PTIB in investigating the affairs of the bankrupt. The point I sought to make, and I apologize if I wasn't clear, was that when a PTIB gets the statement of affairs, if the commercial interest is not aligned with public interest, he can just file it, even though with some level of due diligence, he could unearth reasonable suspicion of offences, which then the official assignee may be interested in to formally investigate and prosecute, depending on the evidence. So I wonder whether, in these circumstances, whether PTIBs still have a role, and if so, how do we align the commercial interests of PTIBs with that of public interest? Thank you.
Well, fundamentally, the administration deals with the same end outcome, which is the better recovery, better and more efficient recovery of assets from the bankrupt estate. So I think that broad architecture will align the interests of both the PTIB and the official assignee. In the example that you cited, perhaps there might be extreme cases where there will be some element which might interest the OA, which might not result in or relate to recovery from the bankruptcy estate. Mr. Murali knows that the statement of affairs, as well as regular reports, are provided to the official assignee. And in those cases, I'm sure the official assignee will be, if his interest is piqued by any of these reports or findings, will take steps to further investigate. And the powers of investigation and indeed any other matters which aid the investigation still continue to lie with the official assignee.
Any other clarifications? Question is that the bill be now read a second time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Insolvency, Restructuring and Dissolution Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
Question is that Parliament will immediately resolve itself into a committee on the bill. As many as of that opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 13 send part of the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
Question is that the bill be now read a third time. As many as of that opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it.
Insolvency, Restructuring and Dissolution Amendment Bill. Item 2, Skills Future Singapore Agency Amendment Bill, second reading.
Order. I propose to take a break now. I suspend the sitting and will resume the chair at 17:45 hours. Order. Order.